The call came through on a Tuesday morning while I was standing in the parking garage of the county courthouse, keys still in my hand, engine ticking as it cooled. My brother's wife answered on the second ring. She had been expecting good news. What she got instead was her own attorney's voice cracking through the speaker loud enough that I could hear every word from 6 feet away, even through the concrete and the ambient hum of the fluorescent lights overhead. She already submitted everything. Tell me you stopped her. Nora, tell me she didn't file. I watched her face from across the hood of her car. She had not seen me yet. She was facing the elevator, one hand pressed flat against the cold metal door, and I watched the composure she had been performing for the past 4 months leave her body the way heat leaves pavement after sunset. Slowly at first, then all at once. I had filed 47 minutes earlier. I should explain how I got there, because the parking garage scene doesn't make full sense without the 14 months that came before it. My mother's diagnosis was not a surprise exactly, but it was still a door closing. Early onset Parkinson's, confirmed in the spring of my 28th year. 2 weeks after she had called me because she'd dropped her coffee mug 3 mornings in a row and couldn't figure out why her hands weren't listening. She was 61. She had just retired from 26 years teaching 4th grade. She had plans, a road trip along the Oregon coast, a vegetable garden she'd been sketching in a notebook for a decade, a watercolor class at the community center on Thursday evenings. The diagnosis didn't erase those plans immediately, but it began the process of revision. I am a paralegal at a civil litigation firm. I have spent 6 years reading documents that other people sign without fully understanding, flagging provisions that only become visible once something goes wrong, building paper trails that courts rely on when memory and goodwill have both run out. It is not glamorous work. Most of what I do involves spreadsheets and deposition transcripts and exhibit binders that no one outside a conference room will ever look at, but it trained me to pay attention to the fine print inside relationships, to notice when the terms of an arrangement shift without anyone formally acknowledging the shift. The arrangement in my family shifted approximately 4 months after my mother's diagnosis. My brother Elliot is 7 years older than me. He lives in Scottsdale with his wife Nora, who has an Instagram account dedicated to what she calls intentional living, which appears to involve a great deal of linen clothing and strategic flower arrangement. Elliot runs the sales division of a mid-sized software company. He is the kind of man who speaks fluently about work-life balance while structuring his actual life to contain very little of either inconvenience or accountability. He called me the week after my mother's diagnosis to express concern, and then he called me twice more over the following 3 months, each time from what sounded like a restaurant, each time cutting the conversation short because he had someone waiting. I was the one who drove my mother to her neurology appointments. I was the one who researched physical therapists who specialized in movement disorders, who coordinated with her insurance carrier when they questioned the medical necessity of her occupational therapy sessions, who sat with her on Tuesday evenings learning which pill did what and when and what the side effects would feel like and how to tell the difference between a bad symptom and a manageable one. I built a filing system for her medical records that ran across 4 binders and a color-coded spreadsheet. I updated it every time anything changed. Elliot and Nora visited for Thanksgiving. They stayed at a hotel 15 minutes away because Nora has, as she explained to me in a text, a complicated relationship with guest bedrooms due to her sleep architecture. They came for dinner, brought a very expensive bottle of wine that my mother couldn't drink due to her medication interactions, and Nora spent 40 minutes of the meal telling us about a wellness retreat she was considering in New Mexico. Elliot talked about a deal his company was closing. They left before 9 because Nora had an early flight. My mother watched their rental car back out of the driveway. She didn't say anything. She reached over and put her hand on mine, and that was more than sufficient. The financial conversation started in January, 13 months after the diagnosis, in the kitchen of my mother's house while she was sleeping. Elliot and Nora had flown in for what Elliot described in his text as an important family discussion. He was waiting at the kitchen table when I came downstairs at 7 in the morning. He had a legal pad. Nora had coffee she'd brought from somewhere else. He explained that he had been consulting with a financial advisor. He didn't name the advisor, and that the situation with my mother's estate required some proactive planning. The house, he said, had appreciated significantly and represented a complication. He had been looking at the numbers. He used the phrase looking at the numbers 3 times in the first 5 minutes, which is a thing people do when they want to sound like they are being reasonable while saying something that isn't. The proposal was this. My mother should transfer the house into a joint ownership structure with Elliot as the primary title holder, ostensibly to protect the asset from potential Medicaid look-back provisions if her care needs escalated. He had a document. Of course he had a document. It was printed on paper that felt heavier than normal paper, which I have learned is something people sometimes do when they want a document to feel more official than it is. I asked who had prepared the document. He said a family friend who happened to be in real estate law. I asked for the friend's bar number. Elliot looked at Nora. Nora looked at her coffee. I told him I would need to review it carefully before anything was discussed with our mother. He said he understood completely, that he wasn't trying to rush anyone, that this was just about protecting the family. He used the word family 4 times in the next 2 minutes. In my experience, people invoke family most frequently when they are in the process of extracting something from it. I took the document to my colleague Priya, who is a real estate attorney and does not owe my brother any favors. She read it in 20 minutes and then looked at me with the specific expression of someone deciding how directly to say something. The document, she told me, would have effectively transferred the majority of the property's equity to Elliot upon our mother's death. The Medicaid protection framing was partially legitimate as a concept. Look-back provisions are real, but the mechanism proposed would not have achieved that purpose. What it would have achieved was consolidating control of the primary asset in my brother's name while my mother was still alive, and while her condition made her potentially vulnerable to signing things she might not fully evaluate. She said the word vulnerable, the way you say it when you want someone to understand that a line has been crossed without having to formally accuse anyone of crossing it. I did not confront Elliot directly. I went home and I thought for a long time about what it means to recognize something you would rather not have recognized. 3 weeks later, Elliot called me from what sounded like a parking lot. He said he'd heard I hadn't moved forward with the document review. I said I was still looking at it. He said the window for this kind of planning was limited, that if we waited too long the options became more complicated, that he was only trying to protect what our mother had worked for. His voice had an edge in it that I had not heard before, or perhaps had heard and categorized differently. He said at one point, "You've always made things harder than they need to be." I wrote that down afterward, not for any particular purpose, just because I have learned, over 6 years of reading other people's legal problems, that the things people say when they are frustrated tend to be more accurate than the things they say when they are composed. I bought a small digital recorder at an electronics store in late February. I tested it in my car. The audio quality was clear enough to capture conversation at a normal speaking volume across a table, which was what I needed it for. I called Elliot and suggested we have dinner to discuss the estate planning in more detail before bringing anything to our mother. I said I had some questions and wanted to understand his thinking better. He agreed without hesitation. People who believe the situation is already resolved tend to find follow-up conversations unthreatening. We met at a restaurant in my mother's neighborhood. Quiet, good acoustics. The kind of place where the booths have high backs and the ambient noise level is low enough that a recorder doesn't have to work very hard. I ordered water. I activated the recorder before Nora finished parking. I asked, with the careful neutrality I have spent years practicing in professional settings, what would happen to my share of the estate if I chose not to sign the transfer document, whether there was a scenario in which I retained my equal interest in the property and we addressed any legitimate estate planning concerns through a different mechanism. Elliot set down his fork. What followed was a 12-minute conversation that I will not reproduce in full because the recording was clear and complete and the transcript speaks without embellishment. What I will say is that Elliot described, in increasingly explicit terms, a set of outcomes he intended to pursue if I disrupted what he called the plan. He mentioned his intention to challenge my mother's capacity retroactively if the estate went to probate without the transfer, which is a thing you can threaten, but which would have been difficult to substantiate given that my mother had documented cognitive assessments from 3 separate physicians. He mentioned, with Nora nodding along, that he had been the one managing the finances in this family for decades, which was not true in any verifiable sense, and that I was a paralegal, not an attorney, and should not be making legal determinations above my competence level," he said with the specific confidence of someone who has never been recorded. "The simplest thing you can do is step back and let me handle it, because if you don't, I will make sure you regret it." Nora added several things that I will spare you, not because the transcript is insufficient, but because they are the kind of things that, once you hear them from a family member, alter permanently how you understand that relationship. The recorder captured all of it, clearly. 2 days later, I sat across from my mother's estate attorney, a careful and methodical woman named Ms. Aldridge who had drafted my mother's original trust documents 6 years prior. Elliot and Nora were also present. Elliot had positioned himself beside Ms. N. Aldridge's desk in the way that people position themselves when they want to suggest authority they have not been granted. Nora sat near the window. They had brought an amended trust document that Elliot described as a minor administrative update, a simplification of the existing structure for ease of management. Miss Aldridge had a copy. I had a copy. I read it in the room. It was not a minor administrative update. The amended document would have, among other provisions, designated Elliot as sole trustee with discretionary distribution authority, removed the equal share language from the remainder distribution section, and included a no-contest clause that would have made any challenge grounds for automatic disinheritance. It was well drafted. The person who wrote it understood what they were doing. I asked Ms. Aldridge several questions about specific provisions, with the slight hesitation of someone who was uncertain and trying to understand. Before she could answer some of them, Elliot answered instead, confirming details and characterizations that were not accurate, doing so with the assurance of a man who had rehearsed this and believed the audience was persuaded. Then I picked up the pen. I signed each page of the amended document with my full signature, dated each one, and slid the stack back across the table. Elliot thanked me with the particular warmth of someone who has just been handed something they were not entirely sure they'd get. Nora smiled at her phone. In the hallway outside, I had 4 minutes. I used them to send 3 emails, one to my mother's original estate attorney, not Ms. Aldridge, who had been retained quietly 2 weeks earlier, one to the county probate court's document submission portal, attaching the audio file and a written summary, and one to the State Bar's Client Protection Division, with a copy of the amended trust document and a note about the circumstances of its drafting. I also sent a text to my mother that said, "Everything went fine today. I'll explain when I see you. I love you." Then I walked back through the building, took the elevator to the parking garage, and sat in my car for a few minutes before I was ready to drive. In the original trust documents, the ones Ms. Aldridge had drafted 6 years ago, before any of this, my mother had included a provision that her attorney had recommended as a precaution. Any beneficiary who attempted to alter, contest, or manipulate the trust through fraudulent, coercive, or deceptive means would be considered to have predeceased the grantor for purposes of distribution. Her attorney at the time had called it a belt and suspenders clause. My mother had apparently agreed without much deliberation, because she had told her attorney, according to his notes from that meeting, that she had read enough about family estate disputes to know she didn't want to be one. The audio recording, combined with the documentary evidence of the amended trust's provisions and the original document's departure from my mother's expressed wishes, was sufficient for the probate court to issue an emergency order freezing the amended trust's execution, pending a full review. That review took 9 weeks. I was in the courthouse parking garage on a Tuesday morning, 47 minutes after filing the supplemental evidence package, when Elliot's attorney called Nora. I had not planned to witness that moment. I was simply still in the garage because the toll machine had jammed and I was waiting for the attendant. I watched her press the phone so hard to her ear that her knuckles whitened, watched her turn and find me standing 20 feet away across the hoods of parked cars, watched her try to formulate an expression for a situation she did not have an expression prepared for. I held her gaze for a moment. Then I walked up the ramp and into the sunlight. The court's final ruling came 11 weeks after that. The amended trust was invalidated. The no-contest clause was deemed unenforceable under the circumstances because the document itself had been produced under conditions the court characterized, carefully, as not consistent with the grantor's independent intent. Elliot's claim to sole trustee authority was denied. The original trust structure was reinstated. The attorney who had drafted the amended document received a correspondence from the State Bar that I imagine was not a pleasant thing to open. I have not spoken to Elliot since. I have not blocked his number, which is different from choosing to answer it. My mother knows the broad shape of what happened. She asked me once, sitting in her kitchen on a Thursday evening while I was updating her medication schedule, whether I was okay. I told her I was getting there. She nodded in the way she does when she has more to say and is deciding whether to say it. Then she reached over and turned the volume up on the small radio she keeps on the counter, and we sat together for a while without talking, which is its own kind of answer. What I keep returning to is something I noticed about the timeline. The moment when Elliot's framing shifted from concern to pressure was gradual enough that I could have missed it. Looking back, the pivot was probably somewhere around the third or fourth phone call, when the word complicated started appearing more frequently than the word help. But the pivot is only visible in retrospect. In the moment, it presented as continuity, as the same conversation with slightly higher stakes, as urgency that could plausibly be attributed to circumstances rather than to intent. I have worked in litigation long enough to understand that most harm doesn't announce itself. It proceeds through accumulated small adjustments, each one defensible in isolation, until the position you are standing in no longer resembles the position you agreed to stand in. The protection is not suspicion. The protection is documentation and attention and the willingness to verify what you are being told, even when the person telling it is someone you are supposed to be able to trust. My mother's vegetable garden is in its second season now. She started smaller than she originally planned because her hands require accommodation. But the tomatoes came in well last August, and she was extremely deliberate in telling me that they were better than anything she bought from a store in 15 years. I believe her. She is not a person who overstates things. I want to ask you something, and I mean it as a real question rather than a rhetorical flourish. If the rearrangement of your life was being proposed by someone who had standing to ask, who framed it as practical and temporary and for the good of the family, how long would it take you to notice the difference between that and something else? And what would you have needed already in place, before the question was ever asked, to be able to answer it clearly? I've thought a lot about what made the difference, not the recording, not the filing, not the clause buried in my mother's original trust documents, though all of those things mattered. What made the difference was something that happened much earlier and much more quietly. I refused to let the discomfort of suspicion talk me out of paying attention. That's harder than it sounds when the person you're suspicious of is your brother. When the history between you is long enough that you've trained yourself to give benefit of the doubt, as a reflex, almost as a form of loyalty. Elliot didn't arrive at that kitchen table one morning having transformed into someone unrecognizable. He arrived as himself, with his legal pad and his rehearsed framing, and what I had to reckon with was that this version of himself had probably always been there. I just hadn't needed to see it clearly before. There's a thing I've noticed in the cases I work on professionally. The people who get taken advantage of in estate disputes are rarely naive. They're usually just tired. They've been managing something difficult for a long time. A parent's illness, a family's grief. The logistics of a life that has reorganized itself around someone else's needs. And the offer to let someone else handle it arrives exactly when the exhaustion is highest. That timing is not accidental. I don't think Elliot calculated it consciously, but I think some part of him understood that I was stretched thin, and that stretched thin people sign things they wouldn't otherwise sign. What I had, that I didn't fully appreciate until afterward, was my profession. 6 years of reading documents that other people trusted without reading. 6 years of watching what happens when the fine print activates and no one had bothered to understand it. That background didn't make me smarter than Elliot. It made me slower to accept summaries in place of sources. And in this particular situation, that slowness protected everything. The cause and effect here is not complicated, even if it was painful. Elliot acted as though my mother's vulnerability and my exhaustion were resources he could draw on. He treated the trust document she had built carefully over years as something to be quietly restructured in his favor. And what came back to him was the consequence of exactly that. A document she had signed years earlier, in a clear mind, with a cautious attorney, precisely because she had thought about what families sometimes do to each other and had decided to prepare for it. She didn't know she was preparing for her own son. I don't think that thought crossed her mind when she agreed to that clause. But she was the kind of person who took seriously the idea that good intentions are not the same as good outcomes, and she built accordingly. That's the thing I keep returning to. Not the confrontation in the parking garage, not Nora's face when the color left it, not even the court's ruling. What I keep returning to is my mother on a Thursday evening, reaching over to turn up the radio, not needing to say anything because some things are understood without language between people who have spent enough time in the same rooms caring for the same things. Integrity doesn't always announce itself. Sometimes it just shows up as someone who kept every receipt, who read the document before signing it, who bought a recorder on a Wednesday afternoon and tested it twice in a parking lot before driving home. Small, unglamorous acts. The kind that don't make good stories until suddenly they make the only story that matters. I'm still working through the rest of it. But I know that what I want to carry forward, from all of it, is the habit of building carefully before anything goes wrong, not out of suspicion, out of respect for the things worth protecting.